let me talk to you a little bit about some of the decisions that have been made by the Supreme Court over many years, starting perhaps with Dred Scott, that adopts the substantive due process argument to determine the constitutionality of various laws. Perhaps the most recent decision by the Supreme Court that was a dramatic departure from previous laws in the states and in the nation was the Obergefell case, which dealt with same-sex marriage. In the opinions that were written there, it was noted that here we are 234 years after the Constitution had been ratified, 135 years since the 14th Amendment had been ratified, that the Supreme Court articulated a new fundamental right, which is a right to same-sex marriage. You're familiar with that case, aren't you?
I am.
At the time, it was noted that 11 states, including the District of Columbia, had passed laws sanctioning same-sex marriage. But also at the same time, there were 35 states who put it on the ballot, and 32 of those states decided to maintain the traditional definition of marriage between a man and a woman. Do you agree with me that marriage is not simply a governmental institution, it's also a religious institution?
Well, Senator, marriages are often performed in religious institutions.
Well, you agree with me that many of the major religions that I can think of, and they're Christianity, Judaism, Islam, embrace a traditional definition of marriage, correct?
I am aware that there are various religious faiths that define marriage in a traditional way.
Do you see that when the Supreme Court makes a dramatic pronouncement about the invalidity of state marriage laws, that it will inevitably set in conflict between those who ascribe to the Supreme Court's edict and those who have a firmly held religious belief that marriage is between a man and a woman?
Well, Senator, these issues are being litigated, as you know, throughout the courts as people raise issues. And so I'm limited in what I can say about them. I'm aware that there are cases.
No, I'm not asking you to decide a case or predict how you would decide in the future. I'm just asking, isn't it apparent that when the Supreme Court decides that something that is not even in the Constitution is a fundamental right and no state can pass any law that conflicts with the Supreme Court's edict, particularly in an area where people have sincerely held religious beliefs, doesn't that necessarily create a conflict between what people may believe is a matter of their religious doctrine or faith and what the federal government says is the law of the land?
Well, Senator, that is the nature of a right, that when there is a right, it means that there are limitations on regulation, even if people are regulating pursuant to their sincerely held religious beliefs.
You agree with marriage is not mentioned in the Constitution, is it?
It is not mentioned directly, no.
And religious freedom and is mentioned in the First Amendment explicitly, correct?
It is.
Do you share my concern that when the court takes on the role of identifying an unenumerated right, in other words, it's not mentioned in the Constitution, and creates a new right, declaring that anything conflicting with that is unconstitutional, that it creates a circumstance where those who may hold traditional beliefs, like something as important as marriage, that they will be vilified as unwilling to assent to this new orthodoxy?
So, Senator, I understand that concern, and because there are cases that are addressing these sorts of issues, I'm not in a position to comment about either my personal views or whether
I'm not asking you to. Justice Alito in the Oberfeld case wrote, he said, "I assume those who cling to the old beliefs will be able to whisper their thoughts in the recesses of their homes. But if they repeat those views in public, they will risk being labeled as bigots and treated as such by government, employers, and schools." So the Oberfeld case, to nerd out with you again, was decided under a doctrine known as substantive due process, correct?
If memory serves, yes, substantive due process, and I think there might have been equal protection concerns mentioned as well.
The Supreme Court has applied that somehow fairly mysteriously by saying it's created by the confluence of the Fifth Amendment and the 14th Amendment to the United States Constitution. But historically, it's been applied in ways that seem to sanction explicit policymaking by the courts. For example, the Lochner versus New York case, which I know you talked to Senator Lee about in particular, which it was a New Deal case which set limitations on how long bakers could work in New York. The Supreme Court struck that down and said it violated the right of free contract. Now, Lochner, as you know, was overruled 30-something years later, but it's also been applied in a number of different circumstances. For example, it's been suggested that Dred Scott, which treated slaves as chattel property, was a product of substantive due process. Justice Hugo Black has criticized the doctrine of substantive due process as the arbitrary fiat of the man or men in power, or the court declaring a law invalid because it shocked the consciences of at least 5 members of the court. He went on to say this use of judicial review thus subverts the liberty of government by the people, overturning laws enacted by legislatures who are answerable to the electorate rather than a majority of the Supreme Court. Finally, he said, for the purpose of my question, he said the adoption of such a loose, flexible, uncontrolled standard for holding laws unconstitutional, if ever it is finally achieved, will amount to a great unconstitutional shift of power to the courts, which I believe, Justice Black that is, and am constrained to say will be bad for the courts and worse for the country. Justice Jackson, why isn't substantive due process analysis just another form of judicial policymaking, which you've suggested policymaking is not in your lane, and you strive to be apolitical, something I applaud. But why isn't substantive due process just another way for judges to hide their policymaking under the guise of interpreting the Constitution?
Well, Senator, the justices have interpreted the due process clause of the 14th Amendment to include a substantive provision, the rights to due process. They have interpreted that to mean not just procedural rights relative to government action, but also the protection of certain personal rights related to intimacy and autonomy. They include things like the right to rear one's children, I believe the right to travel, the right to marriage, interracial marriage, the right to an abortion, the contraception. These
treating slaves as chattel property.
I don't quite remember the basis for the Dred Scott opinion, but I'll trust you that that's...
Well, the fact is it not, that you can use substantive due process to justify basically any result?
Well, the court...
Whether it's conservative or liberal, libertarian, or conservative, whatever you would like to call. It's just it's a mode of analysis by the court that allows the court to substitute its opinion for the elected representatives of the people, and would you agree?
The court has identified standards for the determination of rights under the 14th Amendment substantive due process.
And who gives them the right to do that? If it's not mentioned in the Constitution, where does the right of the court to substitute its views for that of the elected representatives of the people, where does that come from?
Well, the court has interpreted the 14th Amendment to include this component, the unenumerated right to substantive due process, and the court has said that that the kinds of things that qualify are implicit in the concept of ordered liberty, or deeply rooted in our nation's history and tradition. Those are standards that identify a narrow set of activities.
Well, Judge, in the Oberfeld case, Justice Roberts, in his dissent, noted that the court invalidated marriage laws of more than half the states and orders the transformation of a social institution that has formed the basis for a human society for millennia. So that was the basis for the institution of marriage, is the practice for millennia and the recognition that marriage was between a man and a woman. Now, don't get me wrong. I'm not arguing the merits or lack of merits of same-sex marriage. I believe the states and the voters can choose what they will, and that's their prerogative, and I think that's legitimate. But when the court overrules the decisions made by the people, as they did in 32 of the 35 states that decided to recognize only traditional marriage between a man and a woman, that is an act of judicial policy making, is it not?
Senator, the Supreme Court has considered that to be an application of the substantive due process clause of the 14th Amendment. Right.
And it doesn't, the Constitution doesn't mention anything about substance when it talks about due process. The 14th Amendment and the 5th Amendment don't talk about substantive due process. It talks about due process of law. Correct?
Correct.
Well, one of the things that concerns me is here is an example of the courts finding a new fundamental right that is mentioned nowhere in the document of the Constitution. That's the product of simply court-made law that we're all supposed to salute smartly and follow, because 9 people who are unelected, who have lifetime tenure, whose salary cannot be reduced while they serve in office, they decide, 5 of them decide that this is the way the world should be. What other unenumerated rights do you believe exist? And how could we possibly anticipate what those might be? For example, the 9th Amendment says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people, which suggests to me that there are other, as yet unidentified, rights out there, and somehow, someday, some court is going to tell us we've identified an unenumerated right, and we're going to reject the right of the American people to determine what the policies ought to be as regards that right, because we, the 9 people sitting on the Supreme Court, have decided we've discovered a new unenumerated right, and it shall be the law of the land, and no legislature can pass any law that conflicts with it. What other unenumerated rights are out there, or can you say?
Senator, I can't say. It's a hypothetical that I'm not in a position to comment on. The rights that the Supreme Court has recognized as substantive due process rights are established in its case law.
But, Your Honor, this is not a trick question.
Oh, I understand.
Okay.
I'm just not in a position to speak to the.
Well, can you understand why ordinary folks wonder, who do these people think they are, and where does this authority come from? I think the authority comes from we the people. That's the source of legitimacy of government. But when the courts decide to identify an unenumerated right and negate anything that conflicts with it, can't you see how they might feel that this is illegitimate, or a sort of policy making that you have disavowed by saying that you don't want to make policy, you want to stay in your lane? Can you understand the concern?
Absolutely, Senator, I do understand it.
And because I believe the court's legitimacy is very important. That's why I agree with Justice Breyer that, notwithstanding what anybody else says, that should be an aspirational goal of the judges, because we're all concerned about the legitimacy of our institutions, and particularly, I would say, the institution of our judiciary. So how do you as a judge, when you are approaching your decisions, how do you try to avoid being seen as a policymaker by embracing doctrines like substantive due process, which is essentially gives judges carte blanche to do whatever they want?
Well, Senator, I've not had that particular situation, but I have a methodology that is designed to avoid my importation of policy perspectives. The judges are constrained in our system. That's part of the constitutional design. And so in all cases, I am looking neutrally at the arguments of the parties, and presumably in a case like this, there would be arguments made on both sides of the issue.
Well, Your Honor, if you'll forgive me.
Yes.
One reason I think the Supreme Court's different is because in your previous capacity as a trial judge, of course, you were bound by circuit court precedent. And on the circuit court, you're bound by the Supreme Court precedent. But as a member of the United States Supreme Court, you will be bound by nothing. You will be unaccountable to the voters. And so you said you can...
Well, respectfully, Senator, I mean, yes.
So you're not going to be able to find the answer in some law book somewhere. You're going to be presented with a case, and the argument's going to be made, this is an unenumerated fundamental right, and the voters, whatever they've said is irrelevant, because we, 5 members of the Supreme Court, are going to decide what the law of the land should be, and anybody who disagrees with us will be labeled a bigot or be accused of discrimination, even if their beliefs happen to flow from sincerely held religious conviction, like the definition of a marriage between a man and a woman. But you've already told me that you see why this is a concern.
I see why it is a concern, and I would just say that although the Supreme Court is not, bound in the sense of having to apply prior precedent. There is stare decisis in our system. There are now standards in the stare decisis world that the Supreme Court applies when it's asked to.
Thank goodness the Supreme Court has been willing to revisit its precedent, or we'd still be living with Plessy versus Ferguson or Dred Scott. You know, one of the things Senator Whitehouse and I agree on is he and others frequently ask nominees for the Supreme Court, do you think Brown versus Board of Education is settled law? And believe it or not, some nominees won't answer the question. I mean, it boggles the mind. I tend to think that nominees from both parties tend to be overcoached and not and told you can't be, if you don't answer the question, you have a better chance of being confirmed. But some of these things are obviously settled, and I wish we had a more candid conversation about the source of the power that unelected lifetime tenured judges have to basically rule America when they decide that something is an unenumerated fundamental right.